Step out of the vehicle, now!
You have no legal basis to detain me.
You're refusing a lawful order.
I am invoking my Fourth Amendment right.
Stop resisting and get
I
out!
am a federal judge. This is unlawful.
Hands behind your back!
The federal agents didn't knock. They didn't announce themselves properly. They just surrounded her car in the courthouse parking garage and demanded she prove she belonged in America. The woman sitting in the driver's seat wasn't a criminal. She wasn't an undocumented immigrant. She was Judge Diane Richardson, a federal judge with 23 years on the bench, and the next 72 hours would expose a catastrophic failure that would eventually cost the government $8.3 million. Judge Richardson had just finished a long day presiding over cases. Complex litigation involving securities fraud that required her full attention for 9 straight hours. She was exhausted, looking forward to getting home, maybe having a glass of wine and catching up on reading she'd been putting off all week. Her briefcase sat in the passenger seat filled with case files. Her judicial robes hung in the back. Everything about her screamed federal judge except apparently the color of her skin. The agents appeared from nowhere, 3 of them surrounding her vehicle before she could even process what was happening. One positioned himself directly in front of her car, another at her driver's side window. The third, blocking any potential exit from behind. They wore tactical gear with agency insignia she immediately recognized. Immigration and Customs Enforcement. The lead agent, a man in his mid-30s with mirror sunglasses despite being in a parking garage, tapped aggressively on her window. Judge Richardson rolled it down halfway, her legal mind already cataloging every detail of this encounter. She asked calmly what the problem was. The agent demanded identification and proof of citizenship. Not requested, demanded. Now here's where this gets interesting. Judge Richardson could have simply shown her credentials and ended this immediately. She had her federal judge identification in her purse. She had documentation that would have made these agents' faces go pale. But she made a calculated decision in that moment. She refused, because she understood something these agents apparently didn't. American citizens aren't required to carry proof of citizenship. The Fourth Amendment doesn't disappear because someone decides you look foreign. She asked what reasonable suspicion they had for the stop. The agent's response was breathtaking in its inadequacy. He said they'd received reports of suspicious activity in the area, and she matched a description. What description? He couldn't say. Suspicious activity? He wouldn't elaborate. It was the kind of circular reasoning that falls apart under the slightest scrutiny, and Judge Richardson had built a career on scrutinizing exactly this kind of overreach. The interaction escalated quickly. The agent's tone shifted from demanding to aggressive. He told her she was being uncooperative, that her refusal to provide documentation was suspicious in itself, that she needed to step out of the vehicle immediately. Judge Richardson remained seated, hands visible on the steering wheel, voice steady. She explained she was invoking her Fourth Amendment rights against unreasonable search and seizure. She stated clearly she was a federal employee, and this stop was unlawful. That's when the second agent opened her door. What happened next was captured on the parking garage security cameras. The footage would later become Exhibit A in a lawsuit that would make legal history. Judge Richardson was pulled from her vehicle. Her protests were ignored. Her explanation that she was a federal judge was dismissed as an obvious lie, because surely a federal judge wouldn't be a middle-aged black woman driving a modest sedan. Surely a federal judge would be more cooperative. Surely a federal judge would look different. They handcuffed her. Right there in the courthouse parking garage where she'd parked thousands of times over 2 decades. Metal cuffs clicked around wrists that had signed countless orders, ruled on constitutional questions, and upheld the very laws these agents were now violating. The irony was lost on exactly no one, except apparently the 3 people in tactical gear who were making the biggest mistake of their professional lives. Judge Richardson's briefcase was searched without consent. The agents rifled through confidential case files, privileged attorney-client communications, sealed court documents. Every item they touched represented another violation, another federal law broken, another zero added to the eventual settlement. They found her judicial credentials immediately. One agent held up her federal judge identification badge, studying it like he was examining a potentially counterfeit bill. The lead agent's response? He claimed it was probably fake. "People impersonate federal officials all the time," he said. "They'd need to verify her identity at their field office." Judge Richardson asked if they planned to verify by calling the courthouse literally 300 feet away. The agent ignored the question. She asked if they'd be contacting the chief judge. No response. She asked if they understood they were detaining a sitting federal judge without cause. The agent told her to stop talking. They walked her to their vehicle, through the parking garage she'd used for 23 years, past the security station where guards who'd greeted her every morning for over 2 decades watched in confused horror. One guard reached for his phone, presumably to call courthouse security. An agent told him to stay out of it. This was a federal matter. The guard's face showed exactly what he thought of that explanation, but he complied. The drive to the Icefield office took 18 minutes. Judge Richardson spent those 18 minutes in silence, mentally preparing for what came next. She wasn't afraid. Fear requires uncertainty, and she was absolutely certain about how this would end. These agents had just committed career suicide. The only question was how much damage they'd do before someone with functioning brain cells intervened. At the field office, they processed her like any other detainee. Photographed, fingerprinted, personal property confiscated and cataloged. They placed her in a holding cell, an actual cell with bars and a metal bench, and the smell of industrial cleaner failing to mask decades of human misery. A federal judge, in a holding cell, because 3 agents couldn't conceive that a black woman might hold one of the most powerful positions in the American legal system. The supervising agent at the field office, a woman named Sullivan, who'd been with ICE for 15 years, was the first person to actually look at Judge Richardson's credentials with functioning critical thinking skills. She studied the federal identification, ran the badge number through the system, saw the results. Her face went through a remarkable transformation: confusion, realization, absolute horror. Sullivan made 3 phone calls in rapid succession, first to her superior, then to the courthouse, then to the agency's legal department. Each conversation apparently worse than the last based on the progressive pallor of her complexion. Within 40 minutes, the field office had transformed into controlled chaos. Senior officials arrived. Lawyers materialized. Everyone suddenly very interested in the woman sitting calmly in holding cell number 3. Judge Richardson was released with apologies so profuse they bordered on pathetic. The head of the field office, a man who'd been pulled from dinner with his family, personally escorted her out. He used words like regrettable and unfortunate and miscommunication. Judge Richardson said nothing. She collected her belongings, verified everything was accounted for, and walked out of the building with the same dignified composure she brought to her courtroom every single day. But this wasn't over. Not even close. Because what happened in that parking garage and that field office wasn't just a mistake. It was a constitutional violation. It was racial profiling. It was false imprisonment. It was an illegal search. And Judge Richardson knew exactly what remedies existed for citizens whose rights had been violated this egregiously. She'd ruled on cases like this dozens of times. She'd written opinions explaining precisely why this kind of government overreach cannot be tolerated in a free society. Now she was about to become the plaintiff in the kind of case she used to decide from the bench. And the federal government was about to learn an expensive lesson about assumptions. The lawsuit was filed 37 days later. Judge Richardson's attorney was a civil rights specialist named Catherine Moss, who'd built her career dismantling government overreach. She'd won judgments against police departments, federal agencies, and municipalities across the country. When Judge Richardson called, Moss cleared her schedule immediately. She knew exactly what this case represented. The complaint was surgical. 42 pages documenting every constitutional violation in excruciating detail. 4th Amendment violations for the unlawful stop and search. 5th Amendment due process violations. 14th Amendment equal protection violations. False imprisonment. Intentional infliction of emotional distress. The defendants were the 3 ICE agents individually, the field office supervisor, and the federal government itself. The damages sought were substantial but not astronomical. $1.7 million, high enough to hurt, low enough to seem reasonable given what happened, but the money was secondary. Judge Richardson wanted something much more valuable than a settlement check. She wanted accountability. Federal lawsuits move slowly under normal circumstances. But this case was different. The moment it hit the docket, people noticed. Legal blogs picked it up within hours. Major news outlets ran stories by that evening. A sitting federal judge suing ICE for racial profiling and false imprisonment? That's not just news. That's a constitutional crisis playing out in real time. The government's initial response was predictable. They moved to dismiss, arguing qualified immunity for the agents. Qualified immunity, that legal doctrine protecting government officials from liability unless they violate clearly established constitutional rights. The same doctrine Judge Richardson had applied countless times from the bench. But here's what makes qualified immunity interesting. It only protects officials when the law isn't clearly established. When their actions fall into some gray area where reasonable people might disagree about constitutionality, detaining someone without probable cause isn't a gray area. Demanding papers from a U.S. citizen based solely on their appearance isn't a gray area. Arresting someone who presents valid federal credentials isn't a gray area. The motion to dismiss was assigned randomly to Judge Harold Peterson, a Reagan appointee known for strict constitutional interpretation. He denied the motion in a 14-page opinion that legal scholars would cite for years. The key passage addressed qualified immunity directly. No reasonable officer could believe that detaining a federal judge who presented valid credentials falls within constitutional bounds. The right to be free from racially motivated seizures was clearly established long before this incident occurred. Translation: the agents were on their own. Discovery began immediately. Moss requested everything: body camera footage from the parking garage, radio communications, training records for all 3 agents, personnel files, internal policies on immigration enforcement, previous complaints against the agents. She wanted to know if this was an isolated incident or part of a pattern. What emerged during discovery was worse than anyone expected. Agent Daniels, the lead agent who'd first confronted Judge Richardson, had been involved in 4 previous incidents where detentions were later deemed unlawful. 4, all involving people of color, all resulting in quiet settlements paid by the government, none resulting in disciplinary action beyond brief suspensions. Agent Lewis had failed bias training twice. He'd eventually passed on his 3rd attempt, but his training file contained notes from instructors expressing concern about his attitude toward immigrants and minorities. Agent Torres had the cleanest record of the 3, but even his file contained warning signs. 2 citizen complaints in the past 18 months, both dismissed as unfounded, but both alleging racial profiling. The field office supervisor who'd processed Judge Richardson's detention had approved 17 questionable arrests over the previous 2 years. 17 times her agents brought in people without proper documentation of probable cause. 17 times she'd signed off anyway. This wasn't 3 bad agents having a bad day. This was systematic failure. Moss deposed each agent separately. The depositions were brutal. She walked them through the incident minute by minute, forcing them to explain each decision. Why didn't you run the federal badge number immediately? Why did you ignore the judicial identification? What specific articulable facts gave you probable cause to believe Judge Richardson was in the country illegally? Their answers fell apart under scrutiny. Daniels claimed he thought the credentials were fake, but couldn't explain why. He'd never seen fake federal judicial credentials before, didn't know what markers to look for. Just assumed they were fake because he'd already decided Judge Richardson was undocumented. Lewis testified that he'd never encountered a black woman who was a federal judge, so the credentials seemed implausible. Moss let that statement hang in the air during the deposition. Just let the court reporter capture it verbatim. That's the kind of testimony that wins cases. Torres was the smartest of the 3. He repeatedly said he was following Daniels' lead, deferring to the senior agent's judgment. But that defense only goes so far when you're physically restraining someone and ignoring their federal credentials. The government's attorneys tried damage control. They offered a settlement 6 months into litigation, $400,000, and an agreement that the agents would receive additional training. Moss rejected it immediately. Judge Richardson wasn't interested in training programs. She'd seen too many consent decrees requiring training that never changed anything. She wanted consequences. The trial date was set for 14 months after the initial incident. As it approached, something unexpected happened. The government replaced their entire legal team. Out went the mid-level attorneys who'd been handling the case. In came senior lawyers from the Department of Justice Civil Rights Division, people who normally defended the government in cases involving actual constitutional crises. Their first move was requesting a settlement conference with the judge assigned to mediate. Not Judge Peterson, who denied the motion to dismiss. A different judge, someone neutral who could evaluate the case objectively and push both sides toward resolution. The conference lasted 8 hours. Moss presented her case with the precision of a surgeon. Video evidence, deposition testimony. Expert witnesses prepared to testify about racial profiling and Fourth Amendment violations. Damages calculations showing economic loss, emotional distress, and punitive damages. The government's new attorneys didn't fight the facts. They couldn't. Instead, they focused on limiting exposure. They argued that while the agent's conduct was clearly wrong, the government shouldn't be liable for damages beyond compensation for the actual detention time. The mediating judge listened to both sides and gave his assessment. The government was going to lose. Badly. A jury would see a federal judge detained in a parking garage for being black. They'd see agents who ignored credentials and training. They'd see a pattern of similar incidents. The verdict could easily exceed $5 million. The settlement offer came 2 days later. $1.4 million. A formal apology from the ICE director. Immediate termination of all 3 agents. Implementation of new training protocols developed in consultation with civil rights experts. Regular auditing of detention practices. And something unusual. The government agreed to congressional testimony about the incident and the systemic issues it revealed. Moss brought the offer to Judge Richardson. They discussed it for 3 hours. The money was close to what they'd requested. The firings were guaranteed. The systemic changes had teeth. The congressional testimony meant public accountability. But was it enough? Judge Richardson thought about the metal bench in that holding cell, the fingerprinting, the humiliation, the constitutional violations. She thought about every other person who'd been detained unlawfully by these agents and hadn't had federal credentials to prove their citizenship. People who'd been deported, families separated, lives destroyed. She accepted the settlement with one addition. Part of the money would fund a legal clinic providing free representation to people challenging unlawful immigration detentions. The government agreed. The settlement was announced on a Tuesday morning. News coverage was immediate and extensive. A federal judge had sued the government for racial profiling and won. 3 agents lost their careers. Policy changes were mandatory. And most importantly, the incident was now part of the public record, documented, undeniable. Agent Daniels released a statement through his attorney claiming he'd been scapegoated, that he'd followed his training and made reasonable judgments under difficult circumstances. The statement landed like a lead balloon. No one bought it, but the consequences weren't finished. Not even close. The settlement wasn't the end. It was barely the beginning. Within 48 hours of the announcement, congressional hearings were scheduled. The House Committee on Homeland Security wanted answers. How had 3 federal agents detained a sitting federal judge without consequence until she sued? What training failures allowed this? How many others had been wrongfully detained? Judge Richardson was called to testify first. She sat at the witness table in her judicial robes, a deliberate choice. She wanted everyone in that hearing room to remember exactly who had been handcuffed in a parking garage. Her testimony was measured, precise, devastating. She walked through every moment. The initial approach, the refusal to examine credentials, the escalation, the detention, the humiliation. But she didn't stop there. She presented research her legal team had compiled. Over the past 5 years, the same ICE office had conducted thousands of what they called field interviews. 87% targeted people of color. 62% resulted in no enforcement action whatsoever, meaning the stops were baseless. Fishing expeditions, racial profiling dressed up as immigration enforcement. Committee members from both parties looked uncomfortable. This wasn't about partisan politics anymore. This was about constitutional violations happening systematically with government approval funded by taxpayer dollars. Representative Sarah Chen from California asked the question everyone was thinking. How many people were deported based on unlawful detentions? How many families were separated? How many citizens were caught in drags nets designed to catch undocumented immigrants but lacking any real targeting criteria beyond skin color and language? Nobody had solid numbers. That was part of the problem. The data wasn't tracked properly. Or perhaps it was tracked and simply never analyzed. Either way, the lack of accountability was staggering. The ICE director testified next. He was defensive from the start. He claimed the agents involved in Judge Richardson's detention were outliers, bad apples, not representative of the agency's culture or training. He insisted that protocols were in place to prevent exactly this kind of incident. Then, Moss stood up. She'd been granted time to question the director directly. She pulled up the training materials the agents had received. Page after page of procedures for verifying identity, examining credentials, and de-escalating encounters. Everything Daniels and his team had ignored. But here's where it got interesting. Moss then presented internal communications she'd obtained through discovery. Emails between supervisors discussing quotas. Not official quotas, because those were illegal. But productivity expectations. Agents were evaluated based on how many people they detained and processed. Quality didn't matter. Numbers did. The director's face went pale. These communications weren't supposed to exist, or at least weren't supposed to become public. They revealed what everyone suspected but couldn't prove. The system incentivized aggressive enforcement without regard for accuracy or rights. One email stood out. A supervisor had written, "Don't waste time on extensive verification in the field. Detain anyone who seems questionable and sort it out at the facility. We need to hit our targets this quarter." That single email demolished the bad apple narrative. This wasn't 3 rogue agents. This was policy. Unwritten, unofficial, deniable policy. But policy nonetheless. Congressional hearings don't typically result in immediate action. They're usually theater. Politicians grandstand, witnesses deflect, nothing changes. But sometimes, rarely, they create enough pressure that change becomes inevitable. This was one of those times. Within 2 weeks, the Department of Homeland Security announced a comprehensive review of ICE detention practices. Independent auditors would examine field operations in every major city. Training would be overhauled. Supervisors who'd sent those quota emails were placed on administrative leave pending investigation. But the ripple effects extended further than government reform. Civil rights organizations that had been fighting these battles for years suddenly had a perfect test case. A federal judge who could articulate exactly what millions of immigrants and people of color experienced but struggled to prove in court. Legal clinics began using Judge Richardson's case as a template. They filed dozens of lawsuits on behalf of people who'd been unlawfully detained, people who didn't have federal credentials or law degrees, people who'd been too afraid or lacked resources to fight back. Maria Santos was one of them. She'd been stopped outside a grocery store 3 years earlier by the same agents who detained Judge Richardson. She was a U.S. citizen, born in Texas, lived there her entire life. But she spoke Spanish to her mother on the phone while loading groceries into her car. That was enough. The agents demanded identification. She showed them her driver's license. They claimed it could be fake and detained her for 6 hours before confirming her citizenship and releasing her without apology. She'd been terrified to complain, afraid of retaliation, afraid nobody would believe her. Now, with Judge Richardson's case as precedent, Maria had attorneys lining up to represent her. Her lawsuit was filed 4 months after the settlement. It included similar claims: racial profiling, unlawful detention, constitutional violations. and it cited Judge Richardson's case extensively. The government tried to distinguish the cases. Maria wasn't a federal judge. She didn't have the same credentials, but the core facts were identical. Citizens detained based solely on appearance and language. Rights violated. No probable cause. Maria's case settled within 8 months. The amount wasn't disclosed, but sources close to the negotiations said it was substantial. More importantly, it established that you didn't need to be a judge to have rights. Citizenship alone was enough. 17 more cases followed, each one adding pressure, each one costing taxpayers money, each one revealing the scope of the problem. But not everyone saw this as progress. Agent Daniels certainly didn't. After being fired, he'd struggled to find work. His law enforcement career was finished. Nobody would hire someone terminated for detaining a federal judge. He'd applied to private security firms, corporate investigation companies, even retail loss prevention. Everyone passed. He blamed Judge Richardson. In his mind, she'd overreacted, made a federal case, literally, out of a simple misunderstanding. He'd been doing his job, following orders, meeting expectations, and now his life was ruined. Daniels started giving interviews. Conservative media outlets loved his story. Government overreach, political correctness run amok, an agent destroyed for trying to enforce immigration law. The narrative ignored every actual fact of the case, but it played well to certain audiences. He appeared on podcasts claiming he'd been targeted for being effective, that Judge Richardson had pulled strings to destroy him, that the settlement was hush money to cover up her own suspicious behavior. None of it was true. All of it got traction. Judge Richardson didn't respond publicly. She didn't need to. The facts spoke for themselves. The video evidence, the court filings, the settlement terms. Everything was public record. People who wanted truth could find it. But Daniels' media tour did accomplish something unintended. It kept the story alive. Every interview reminded people what had happened. Every podcast appearance generated new articles. Every social media post brought more attention to systemic problems in immigration enforcement. Organizations fighting for immigrant rights used Daniels as a perfect example of why reform was necessary. Here was an agent who still, after everything, couldn't acknowledge wrongdoing, who saw no problem with his actions, who blamed his victim for consequences he'd brought on himself. Meanwhile, the other 2 agents involved stayed silent. They'd also been fired, also struggled to find work. But they'd made different calculations. Fighting publicly would only make things worse. Better to fade into obscurity and hope people forgot. The legal clinic funded by Judge Richardson's settlement opened 6 months after the announcement. It was staffed by experienced immigration attorneys and law students from nearby universities. The demand was immediate and overwhelming. Hundreds of people came forward with stories of unlawful detentions, traffic stops that turned into immigration interrogations, workplace raids where citizens were detained alongside undocumented workers, home visits where agents demanded papers without warrants. Not every case was viable. Some lacked evidence. Others fell outside statutes of limitations, but enough were solid that the clinic filed a new lawsuit almost weekly. Each one chipped away at the system that enabled these violations. The financial impact on the government was substantial. Settlements were adding up. Legal defense costs were mounting. Insurance premiums for law enforcement agencies were increasing. Suddenly, unlawful detentions weren't just constitutional violations, they were budget problems. And budget problems get attention in ways moral arguments sometimes don't. Agencies started changing policies not because it was right, but because it was expensive. Training programs were revised, oversight mechanisms strengthened, complaint procedures streamlined. Progress driven by financial pain rather than moral awakening, but progress nonetheless. Judge Richardson watched these developments from her chambers. She'd returned to her normal caseload, hearing disputes and making rulings like any other day, but she received regular updates from the clinic. Reports on cases filed, outcomes achieved, lives affected. The numbers told a story of systemic change beginning to take root. 2 years after her detention, she was invited to speak at a law school symposium on civil rights enforcement. She rarely accepted such invitations, preferring to let her work speak for itself. But this felt important. The audience was full of future lawyers, future judges, future advocates, people who could carry this work forward. Her speech was characteristically direct. She didn't dwell on her personal experience. Instead, she focused on what it revealed about broader patterns, how power operates unchecked without accountability, how rights mean nothing if people don't know how to assert them, how systems protect themselves unless forced to change. She talked about the importance of documentation, recording interactions, collecting evidence, building cases that couldn't be dismissed or ignored. She emphasized that individual victories meant little without structural reform, that settling one case while leaving broken systems intact was just putting bandages on bullet wounds. The speech resonated. Students approached her afterward with questions. Some shared their own experiences with unlawful stops and searches. Others asked how they could get involved with similar work. Several mentioned they were reconsidering their career plans, thinking about public interest law instead of corporate positions. One student, a young woman whose parents had immigrated from Guatemala, thanked Judge Richardson for fighting back. She said her father had been detained 3 years earlier at a traffic stop, held for 6 hours despite being a citizen. He'd been too afraid to complain, worried it would bring more trouble. But seeing what Judge Richardson accomplished made him reconsider. He'd filed a complaint last month. An investigation was underway. These ripple effects were impossible to quantify but undeniably real. Each person who stood up made it slightly easier for the next person. Each successful case established precedent for future ones. Each policy change created new protections. Slow, incremental, frustrating progress. But progress. The federal government eventually issued new guidelines for immigration enforcement. They required specific, articulable facts before detaining anyone for immigration status checks, prohibited prolonged detention without cause, mandated better training on constitutional rights, established clearer complaint procedures. Were the guidelines perfect? No. Were they always followed? Absolutely not. But they existed now. Organizations could point to official policy when challenging violations. Lawyers had concrete standards to reference in lawsuits. Judges had frameworks for evaluating whether agents acted appropriately. Daniel's media appearances gradually decreased. The story got old. Audiences moved on to newer outrages. He eventually stopped giving interviews and took a job doing background checks for a small company in another state. He never publicly acknowledged wrongdoing, never expressed regret for what he'd put Judge Richardson through. As far as anyone knows, he still believes he was right. The other 2 agents faded even further from public view. One left law enforcement entirely, last known to be working in construction. The other moved overseas, reportedly doing security work for a private contractor. Neither ever spoke publicly about the incident. 3 years after the detention, the legal clinic had handled over 400 cases. 68 resulted in settlements. 42 led to policy changes at various agencies. 11 produced published court decisions that established new precedent. Countless others were resolved informally when agencies recognized they couldn't defend their actions. The financial toll on government agencies exceeded $12 million. Not just settlements, but legal fees, training costs, policy revision expenses, and increased insurance premiums. Agencies that once treated unlawful detentions as minor issues now had entire departments devoted to preventing them. Judge Richardson continued serving on the bench. Her rulings remained sharp and well-reasoned, her courtroom efficient and fair. She never sought publicity for what happened, never wrote a book or gave paid speeches. The work itself was enough, but she'd changed in subtle ways. Colleagues noticed she was more patient with self-represented litigants who didn't understand courtroom procedures, more willing to explain legal concepts in plain language, more attuned to power imbalances between parties. The experience of being powerless, even briefly, had deepened her empathy for others in similar positions. 5 years after the incident, Congress held hearings on immigration enforcement practices. Judge Richardson was invited to testify. She considered declining. Testifying meant reliving the experience publicly, meant becoming the face of an issue rather than just another person affected by it. meant dealing with hostile questions from representatives who'd rather defend agents than protect rights. She testified anyway. Her statement was measured and factual. She described what happened without dramatization, presented evidence of systemic problems without partisan rhetoric, proposed specific reforms based on demonstrated needs. She didn't ask for sympathy, didn't position herself as a victim, just explained what went wrong and how to prevent it from happening again. Some representatives thanked her for her service and courage. Others suggested she was exaggerating. One implied she'd somehow provoked the detention through her behavior. She responded calmly to each question, never losing composure, always bringing the discussion back to facts and evidence. Nothing immediately changed after the hearings. Congress didn't pass sweeping reform legislation. No dramatic policy shifts emerged. But the testimony entered the official record. It could be cited in future cases, referenced in policy debates, used by advocates pushing for change. That's how progress actually works most of the time. Not through single dramatic moments, but through accumulated pressure over years. Each lawsuit adding weight, each settlement creating precedent. Each policy change establishing new baselines. Slow, grinding, unglamorous work that eventually shifts what's considered acceptable. The legal clinic continues operating. It's handled over 1,000 cases now, secured millions in settlements, changed policies at dozens of agencies, trained hundreds of law students who've gone on to do similar work elsewhere. The ripple effects keep expanding. Unlawful immigration detentions still happen. The problem isn't solved, but it's better than it was. Agents face real consequences now. Victims have clearer paths to justice. Systems have more accountability built in. Not perfect, but improved. Judge Richardson's detention lasted 4 hours. The consequences have lasted years and will continue long after she retires. That's the real measure of what happened that day. Not just one person's experience, but how that experience catalyzed change, affecting thousands of others. She could have accepted the apology and moved on. Could have stayed quiet to avoid controversy. Could have prioritized her comfort over broader impact. She chose differently. Chose to fight back. Chose to demand accountability. Chose to turn personal violation into systematic reform. That choice mattered. Not because it made her special or heroic, but because it demonstrated what's possible when people refuse to accept injustice as inevitable. When they document what happens, build strong cases, push for real consequences, follow through even when it's difficult and uncomfortable. The system doesn't fix itself. It changes because people force it to change. Through lawsuits and complaints and testimony and persistent pressure. Through refusing to let violations slide. Through turning individual incidents into broader fights for accountability. 4 hours in a detention room. Years of impact rippling outward. That's the real story here. Not what happened to one judge one afternoon, but what that judge made happen afterward. The parking garage where it started looks the same as it always did. Cars come and go. People walk to their vehicles after work. Security guards wave at familiar faces. Nothing marks the spot where 3 federal agents made a decision that would cost millions and reshape policy across the country. Judge Richardson still parks there sometimes when she has cases at that courthouse. She's never spoken publicly about whether she thinks about that afternoon when she pulls into her usual spot, whether she glances at the place where agents surrounded her car, whether she feels anything particular when she walks past the security station where guards watched helplessly. What we do know is this: the $8.3 million figure that eventually emerged wasn't just her settlement. It was the cumulative cost across all related cases, policy changes, training programs, and legal fees that followed. Her initial settlement of $1.4 million was just the beginning. The real price tag came from everything her case set in motion. Other agencies learned from what happened. They revised their procedures not out of moral epiphany, but because the alternative was too expensive. Police departments updated their training materials. Border Patrol modified their protocols. Local law enforcement agencies added new sections to their policy manuals about verifying credentials and respecting constitutional rights. The three agents never worked in law enforcement again. Their names became cautionary tales in training academies, examples of what not to do. How assumptions and bias can destroy careers and cost taxpayers millions. Whether they learned anything personally remains unclear. Only one ever spoke publicly, and his comments suggested he still saw himself as a victim rather than someone who'd violated fundamental rights. But the broader impact kept spreading. Law students study the case in constitutional law classes. Civil rights attorneys cite it in briefs. Advocacy organizations reference it when pushing for reform. It became part of the legal landscape, a data point in ongoing fights over immigration enforcement, racial profiling, and government accountability. The clinic, Judge Richardson funded with settlement money, has outlasted initial expectations. It was supposed to operate for 3 years. It's been 7 now, sustained by additional grants and donations. The cases keep coming. People who experienced similar violations but lacked resources to fight back. The clinic gives them what Judge Richardson had: skilled attorneys, documented evidence, and the determination to see cases through. Not every case succeeds. Some lack sufficient evidence. Others run into procedural barriers. A few get dismissed on technicalities. But enough win that the work continues. Each victory makes the next one slightly easier. Each settlement establishes precedent. Each policy change creates new standards. The system still isn't fixed. Unlawful detentions still happen. Racial profiling persists. Power still gets abused. But there's more accountability now than before. More oversight. More consequences. More people willing to fight back because they've seen it's possible to win. That's what Judge Richardson's case ultimately demonstrated. Not that justice is guaranteed, or that one lawsuit can fix systemic problems, but that fighting back matters. That documentation and persistence can overcome institutional resistance. That sometimes the system does respond when forced to confront its failures. She went back to work the day after her release from detention, heard cases, made rulings, performed the job she'd been doing for over 2 decades. She didn't let what happened define her or derail her career. She simply refused to accept it as normal or inevitable. 4 hours changed years of policy. One person's refusal to stay silent created space for hundreds of others to speak up. A single case sparked reforms that affected thousands. Not because Judge Richardson was special, but because she understood something fundamental about how change actually happens. It happens when people refuse to accept violations as the cost of existing in their own country, when they demand accountability instead of apologies, when they transform personal experience into systematic pressure. When they do, the unglamorous work of documentation and litigation and testimony, the parking garage looks the same. But the world around it shifted slightly. Not enough, never enough, but more than before. And that difference, small as it might seem, represents real lives affected, real rights protected, real accountability enforced. That's the measure of what happened when 3 agents made assumptions based on skin color and a federal judge decided those assumptions would cost them everything. This case was brutal, but the case on the right spirals completely out of control.